Good morning. I call this oversight hearing to order. Today we will examine the Small Business Administration's Native 8A program and the role that it plays in economic self-determination of our Native communities. This isn't a new topic for oversight. We have regularly conducted oversight of this program, and that remains important because 8A, in this senator's view, is a success story. It's not a fraud, as some have mistakenly alleged, and quite honestly, that's terminology that I would just categorically reject. This program may not be well understood, which may be part of our challenge here, but it is important to note that it simultaneously provides benefits to the federal government and to Native communities all across our country. That's true in Alaska, that's true in Hawaii, and in most every state. As structured today, the 8A program leads to a more responsive and resilient supply base for the federal government. It delivers mission-critical work for civilian and defense agencies, and it promotes economic development in Native communities while helping to fulfill the federal trust responsibility. Now, lately, we've seen some criticisms that 8A is an illegitimate DEI program. Also concerns over whether revenues and earnings are leading to sufficient community benefits. Now, on this first question, I do have a letter from SBA Administrator Kelly Loeffler confirming that the Native SBA 8A program is not DEI, which I will enter into the record. As the Committee with Jurisdiction over Tribal and Native Affairs, these are matters that we must explore here with testimony from those that are involved in the program. As we engage on this, I think we should start by making just a few things clear. First, the United States has unique obligations to Indian tribes and Native people that are grounded in the United States Constitution, in our treaties, in our statutes, in our court decisions, and executive orders. And based on that, beginning in the 1980s, Congress chose to make Native entity-owned firms eligible for the 8A program. And that was not based on race, it was not based on DEI, but it was based on Congress's constitutional authority over Indian affairs and the longstanding federal trust responsibility to Native peoples. Second, the firms owned by tribes, Alaskan Native corporations, and Native Hawaiian organizations participate in the 8A program under a different statutory framework than firms that are owned by individuals. But that, too, is deliberate. That's not an accident, that's deliberate. Congress set up this framework because Native entity-owned firms are accountable to entire Native communities. That's a different responsibility. They're accountable to entire Native communities, reinvesting their earnings in broader community priorities and advancing economic self-determination. Third point, Congress has reaffirmed and expanded the inclusion of Indian tribes, ANCs, and Native Hawaiian organizations in the 8A program. And these were also deliberate decisions and remain the right decisions, in my view, so long as we maintain the program integrity and the transparency. Now, some suggest that by restricting 8A eligibility, we're suddenly going to save a ton of taxpayer dollars, but in truth, it would actually cost the federal government a key contracting tool and further disadvantage Native peoples around the country, excluding them from any potential participation in federal procurement and the community benefits that they provide. And that's especially true in Alaska, where Congress took a different route. They did that as they settled the Aboriginal land claims. It was different than in the lower 48, but they transferred land and assets to corporations that are owned by Alaska Native people. That distinctive structure reflects Congress's recognition of the unique circumstances of Alaska Natives and supports their self-determination. Congress actually amended ANCSA, or the Alaska Native Claims Settlement Act, to clarify that ANCs are eligible to participate in 8A and that they were acting under their constitutional authorities, making access to federal procurement programs a key part of the settlement and Alaskan Native economic development. When Congress passed ANCSA, one of the goals was to connect communities that were primarily reliant on subsistence hunting and fishing, essentially non-cash economies, but seeking to help advance them within the American business world. The 8A program has been pivotal to that, building up managerial, leadership, and business capacity in Alaskan Native communities. Now, I know that some colleagues and federal agencies are conducting reviews of the 8A program, including participation of Native-owned entities. And those reviews must be based on facts and in the law, ensuring that SBA and agencies are equipped to administer an effective program as Congress intended, while targeting any waste, fraud, and abuse. I think we all recognize that we don't want to see that within our system. So I'm pleased that today we're able to focus very keenly on some of these issues today. I'm looking forward to hearing from our witnesses who are involved in Native 8A contracting, including those who have traveled down from Alaska to testify before us. Thank you for that. They will share how the 8A program advances economic self-determination and tribal self-sufficiency in a manner consistent with congressional intent that is good for Native peoples. So I now turn to the Vice Chair for his opening statement.